All right. Yep, so I think we got the Ustream going. Get this tweet out right quick. And welcome to the Friday class. I am Nuna GL. And welcome, thank you for joining us yet again. Islam, everybody checking us out on the Ustream and the YouTube world. Thank you. Without you, this wouldn't be possible. So we thank you guys, of course. Today, Islam, we are supposed to be talking about the writ of error, Islam, and I gave some homework through the active space. If you, I linked up with activemoors.com, and we had a few definitions and words that we were supposed to go over. But today's class is supposed to be writ of error, Coram Nobis versus Coram Vobis, in a review of the vital protocols of liberty. So we're going to get right into it, and just for the sake of time, I'm going to run through some of the definitions. Some of them we already have covered before. Some of them were part of the homework, but I just felt like they would be pertinent to go into. But before we do that, I wanted to read just two or three of the oral statements and prophecies, Islam, and then we'll just jump right to it. So number 35, we the Moors have the blood of every nation flowing through our veins, thereby bringing about a cross spirit. 36, the Italians have our blood, the blood of the Moors, mixed in their veins. That is why they are so mean, quote unquote. Number 37, quote, we, the Moors, are a hard-headed, stiff-necked, mean set of people that have never did anything except at the point of a sword. Islam. And then this next one, which, for better or for worse, take it how you want to. 41, quote, I had to go around my elbow to get to my thumb to get what I wanted established in this government. I repeat, quote, I had to go around my elbow to get to my thumb to get what I wanted established in this government. Islam, that's number 41. So, with that being said, sometimes it's not the help that you're looking for is not always going to come in the form that you expected. The way that you go about something isn't always going to be the way you may right now at this very moment think that that's the way to go about it, right? And sometimes you in the terms of doing things the right way, you might go out of your comfort zone a little bit. You might do some things in terms of work, or you might have some areas in terms of study that may be a little more intense or a little more draining than usual. So as a precursor, as a warning, I just want to let everybody know that when you're studying, don't so much make it a habit of going hard 24/7 and staying up every night, all night, and not being able to do what you need to do. Because at the end of the day, you do have a life to live. You know what I mean? And as you're growing and as you're coming out of whatever situation you're coming out of, you want to be stable you know, you want to be reasonable about how you're moving. So just be aware as you're studying and as you're gaining information, to be cautious about when you apply it, because certain, you know, like I said, certain areas are a little more, you know, dangerous than others, depending on whatever circumstance or situation you're talking about. So, you know, do your due diligence at all times. Islam, always do your due diligence. So I just preference that to say, because oftentimes, you know, and in starting this, I guess this leg of the series of teaching, I got a lot of different questions from people, and I just wanted to make sure that, you know, people weren't taking these lessons lightly, because these are keys, you know, to your posterity. These are ways and means in so many ways to defend yourself. And it's often been, you know, in my past experiences, you know, with teams and things of that sort, and understanding of sports, that the best offense typically is a good defense. Islam. And if you're into football at all, I believe it might have been Vince Lombardi or someone, you know, of his stature and character, that says something along the lines of defense winning championships, you know, in our recent era. But just keep these, you know, tidbits in mind. They're just, you know, little well-seasoned breadcrumbs for those who have eyes to see and ears to hear. But we are going to get right into it. So the definitions for today, and I'm gonna start from the top of my list. I got a little list today to keep me on track. It's long, so that we can move right through it and, you know, get everything we need to on the record, because I often, you know, want to get so much on the record. But anyway, free white persons. So first one, Islam. Islam. Free white persons. Free white persons, referred to in Naturalization Act as amended by Act July 14th, 1870, has meaning naturally given to it when first used, you know, one statute, meaning all persons belong to the European races, then commonly counted as white, and their descendants, including such descendants in other countries to which they have immigrated, right? And it goes on to say below it, it includes all European Jews, more or less intermixed with peoples of Celtic, Scandinavian, Teutonic, Iberian, Latin, Greek, and Slavic descent. It includes Magyars, Lapps, and Finns, and the Basque and Albanians. It includes the mixed Latin, Celtic, Iberian, and Moorish inhabitants of Spain and Portugal, right? So right there, it tells you that free white persons are Moors. You know what I mean? They were the inhabitants of all these areas. They were known by all these various names and the like, right? It goes on to say the mixed Greek, Latin, Phoenician, and North African inhabitants of Sicily, and the mixed Slav and Tatar inhabitants of South Russia, right? Period. And this is coming out of, again, Black's Law, 4th edition. For those who don't know, page 792. Now, right after that, it's going to make a clear distinction as to what free white persons does not mean. All right? Follow me. It does not mean Caucasian race, Aryan race, or Indo-European races, nor the mixed Indo-European, Dravidian, Semitic, and Mongolian peoples who inhabit Persia. A Syrian of Asiatic birth and descent will not be entitled to become a naturalized citizen of the United States as being a free white person. And that's, you know, more of a legal versus a lawful distinction. And then they make another legal versus lawful distinction. Nor a native-born Filipino, nor a native of India who belong to Hindu race, right? Which we know our Hindustani brothers are, you know, our brothers and sisters. But this is more so applying to the peoples of those areas and who more or less migrated to northwest Amexem in this case. All right. And just for the sake, well, I'll wait on that because we've done that before. So I'm gonna stick to this list. Color is next. So yeah, I just wanted to put free white persons on the record because, again, I was getting a lot of questions, and if you've seen any of the past videos, you know this been coming up lately. There's been this question between, you know, and we actually had a class, you know, coming through the Moorish directory. Shout out to Sister Sharice L. And Brother Rami Il and Brother Cujo Awa Il for their naturalization versus nationality class, right? And in that they make some clear distinctions between, you know, those definitions, which I won't necessarily get into in great detail to here, but suffice to say that if you are able to make those distinctions, right, between what applies to nationals versus what applies to naturalized citizens, right? So nationals of the land, naturalized citizens, right, who are naturalized by the government or, you know, and or the people of the land in some way, shape, or form. You're gonna constantly run into issues, and if you follow, right, conceptually, if you follow the citizens process when you should be following or protocol, when you should be following the nationals process or protocol, you're oftentimes gonna, you know, reach a dead end. And no, you know, I've built with numerous Moors. We've you know, dealt with different things. And the number of, you know, the one reoccurring thing, the common denominator, sorry, that I keep running into is that as we're growing, and this is why I preference, you know, applying certain information without having a true, full understanding of it and the application of it, you know what I mean? And, you know, truly being willing to demonstrate that for yourself, you know, once you're assured of yourself that you know it. Being willing and you know, honest enough to demonstrate it, you know, of course that takes a certain amount of courage. But once you do that, now you have the experience to speak from, or the position to say, hey, I've been there, I've done it, you know, it either worked or it didn't, you know what I mean? And this is why I left it alone, or this is why I adjusted my strategy, you know, or my ways and means of going about it, Islam. So, you know, just, again, some tidbits, well-seasoned breadcrumbs. I just felt that needed to be out there because, again, when you're dealing with that process or that question of naturalization versus nationality, it is going to be determined based on your heritage at the end of the day. And rooted in the word, you know, based on etymology, is her, you know. So you're going to have to ask your mother where you came from in some way, shape, or form. You know, and if she's gone, then, you know, DNA is all, you know, testing is always available in these modern times and era. So, you know, to whatever degree that you trust and believe in that, you can do that, or you can ask other family members, you know, who may be around. But it's best always to verify through proper documentation, or, you know what I mean, through other means within the family, to try to secure that information. That's why it's so important to take records and you know, certain documents amongst the family seriously. And, you know, in my house, as quiet as it's kept, I used to institute, you know, contracts, you know, for different things when you know, situations would come up that would require certain business transactions and things of that sort. And, you know, anybody can tell you that those contracts help keep, you know, things clear. As, you know, time goes on and, you know, people stray from their stated or intended means, you know, or purpose. So, you know, again, conceptually, keep in mind the purpose of all of these instruments when we're talking about writs, when we're talking about contracts, when we're talking about, you know, notices, public and private. They have their purpose, and if you're able to understand their purpose, you know, from a core standpoint, you will be able to be a lot more effective when you use them. I promise you. But typically, most of the time, people are going through things with, you know, partial knowledge or incomplete knowledge, and, you know, a complete lack of experience. And so that, you know, oftentimes is going to lead to you learning the hard way, you know, whatever way that may be. Or you might learn a quick way, you know, depending on how you look at it. But the next word I wanted to look up, you know, when I'm jaw jacking and talking, and just, you know, again, just giving certain conceptual things that I you know, I felt like really needed to be out there, because it seems like there was a lot of confusion as to, I guess, how Europeans, some have been able to seemingly become nationalized, which the process wouldn't technically be nationalization, it would be, you know, naturalization for a foreigner of any sorts. But for us, you know, us being from the land, we are naturally attached to it. But because of, you know, the auspices of slavery and things of that sort, we have color, right, associated with our personage, right, which we've talked about personage before, but I will pull that up just right quick while I'm, you know, I got my fingers on this. Matter of fact, I'm gonna put a pin here. But yeah, so that we, you know, we're clear when we're talking about these words. And that's why I'm taking the time, if some of you wondering, you know, why do I take the time to put this stuff on the record, is because most people don't. And, you know, after I put so many of these definitions on the record, we're not going to go over these like this. I'm letting you guys know. But I'm doing this again for the record, and for those who may not have the ways and means. But I'll do that later. I want, for the sake of time, I'll go and hit this. So color, because when you're talking about personage, all I wanted to show you was that you're talking about, you know, you've got a distinction between corporate persons, you know what I mean, natural person, and, you know, other types of personage, you know, and its various means. But anyway, for the sake of time, we'll get right into it. So colored, or color rather, means appearance, semblance, or simulacrum, as distinguished from that which is real, a prima facie or apparent, right? Hence a deceptive appearance, plausible assumed exterior concealing a lack of reality, a disguise or pretext, right? So right there, in so many words, is something fake. Something colored is something fake, right? Now when you're talking about in pleading, and you're talking about, you know, operating, knowing that you're a Moor, or, you know, by blood right being a Moor, but trying to operate as a citizen without full understanding of what the difference is, you know, or trying to use those protocols. In pleading, ground of action, quote unquote, ground of action admitted to subsist in opposite party by the pleading of one of the parties to an action which is so set out as to be apparently valid, but which is in reality legally insufficient, right? When you're doing these things, those processes are coming back and proving themselves to be legally insufficient because the processes are colored. You have to make the distinctions. You have to be very clear in your language. A term, this is further in the definition of color, a term of the ancient rhetorics, or rhetoricians, pardon me, of early adopted into the language of pleading. It was an apparent or prima facie right. And the meaning of the rule that pleadings in confession and avoidance should give color was that they should confess the matter adversely alleged. So you gotta sort of make a all right, I'm just gonna keep reading. To such an extent, at least, as to admit some apparent right in the opposite party. So you got to admit some apparent right in the opposite party. So you got to prove adversely, or plead guilty, essentially. Typically, that's what they call it nowadays, right in the opposite party. So you got to, you know, plead guilty. You're saying that there's some, you know, conditional or partial right in the other party, which required to be encountered and avoided by the allegation of a new matter, right? To avoid them bringing up a new matter to argue the validity, you know, what have you. Color was either expressed, i.e., or for example, inserted in the pleading, or implied, which was naturally inherent in the structure of the pleading. Islam. So when they give you, when they, being, Europeans, being the corporatocracy, de facto entities, give you their carbon copies and forms to fill out, and you don't make certain reservations or, scratch out certain things, there's a certain inherent form of color associated with that document. And without those certain reservations and points of order being clarified, you might be considered, based on this last definition, if you look like me, copper tone, that is, to be associated with this definition, right? The word color also means the dark color. So the word, quote unquote, color also means the dark color of the skin, showing the presence, in their opinion, according to this definition, of Negro blood. And hence, it is equivalent to African descent or parentage. Right? Now, this is according to the case law within this particular edition, Johnson v. Board of Education of Wilson County. All right? So you can see that to determine Islam. Let me just go on and reset the room. But you can see that just to determine whether or not what I'm saying is true or not. Don't take my word for it. But then they got color of law, color of office, color of authority, right? And then you jump down over to the next page. Now this is 332 Islam, eyes to see. Sort of towards the middle here on the right hand side. Colored by common usage in America. Now how did it become a common usage? I wonder. Maybe it was the slave codes. Maybe it was the Jim Crow era. I don't know. We'll see. This term in such phrases as quote unquote colored persons, quote unquote the colored race, quote unquote colored men, and the like is used to designate Negroes and persons of the African race, including all persons of mixed blood descended from Negro ancestry. Right? Interesting. Now it goes on to say, and it's got some case law there if you want to check that out. Got a couple of cases actually. Three cases. But where a state constitution provided for separate schools for the white and colored races, the term quote unquote white race was held to be limited to the Caucasian race, and the term colored races to embrace all other races. Now see how they flip-flop between the definitions? How they created they honored the treaty and the Constitution by, having the definition of free white persons, making a distinction between, who the Moors were as being free white persons, and then saying who the Europeans were not being free white persons. But then they created, if you notice, under the de facto auspices, right, their own, creation, their own Frankenstein known as the colored, right? Also, AKA known as the Negro. Right? These are tags, these are labels that the Prophet was talking about. These are the things that we're trying to build up a defense against in terms of presumptions and assumptions. Islam, legally or otherwise. Because those presumptions and assumptions will allow you to be classified as property, typically. Because depending on the person that you are, you could be considered a corporate person and, be tied up under their things. But, right now we've got a lot of international support, on a lot of ends. We've got a lot of people that's been reaching out, and they know that we are the true Al-Moroccans, we're the true heirs of the vast estate. And they keep asking, us and other Moors who, they've been in correspondence with, why, it's taking so long for us to get in gear, with things. And for for so many reasons, for so many, issues, I can only sum it up to be, a number of a few things. But for sake of time, right now, we'll just say the U.S. nigger industry and its well-oiled machinery has been, just doing a fantastic job of keeping people asleep up until this point. But with a clear understanding, Islam, of who you are, what you're doing, when you start talking about this writ of error, you'll be able to find all types of and manners of violations. And the better you know yourself, and the things that you have a understanding and control of, the better you can hold those would-be trustees accountable for their said, auspices and duties, which we all know have caused, massive furloughs and debasement of currency and certain values and specie on, numerous scales and levels all across the planet. But until this point, the natural heirs have, for whatever reason, been unable to recognize the silent weapons, for quiet wars that's been, in effect against them, and instead have been, misplacing the blame on all these other symptoms, as Tyre says, rather than dealing with the root causes, Islam. And the writ of error is one of those things that, helps put a check to that, once the damage has already been done, or, in the process of trying to prevent, certain other things from going on. But I just wanted to reiterate that because, again, I gave the homework, for you guys to read, and, I expect you guys to read it, but, I just want to really just have a conversation with y'all about what it is that you read, So let me jump into some of that material right quick, because there were some distinctions I wanted you guys to just know from a, historical and procedural standpoint, just so that you have a better understanding of what you're doing, and again, the broad scope, Islam, of the writ system, and that era of law, and the reasons, and as you understand the broadness of it and the complexity that was entailed in it, and performing it and maintaining it, you'll begin to see in so many ways the beauty of it. And hopefully, based on, knowledge and understanding and wisdom, be able to kind of see the modern applications for them. When certain, how should I put it, de facto corporations decide not to do their due diligence and, trusted duties, you can, again, point out and bring to the court's attention certain errors, at law. And typically you're either talking from the perspective as a noble, or, as an administrator, or as an administrative body talking to another administrative body or judicial body, right? In today's terms, because most of these operations aren't judicial at all. Most of them are administrative when you really get down to it, to the nitty gritty of it. But let's get right into it. Now, this is something I found, and you can check the source on the active space if you want to. But I'm just going to read a couple of things here. The writs of error, Coram Nobis and Coram Vobis, right? And this was Edward N. Robinson, Islam. So, after the completion of an unsuccessful litigation, an attorney may find that certain facts existed which, if they had been brought to the attention of the court during the trial, would have prevented the judgment. Yet, the more familiar procedural remedies may be inappropriate or may have long before expired, leaving him without apparent recourse to the courts. With origins buried deep in the annals of procedural history, there is a common law writ known as the Writ of Error, Coram Nobis, Coram Nobis, or Coram Vobis, which has aided many a client and lawyer in the hour of desperation. It is the purpose of this article to reacquaint the lawyer with certain aspects, or lawman, with certain aspects and characteristics of the writ, and to consider its availability to jurisdictions where it has not been abolished. Right now, this is a public document. You can Google it, find it. I didn't even look on Google Scholar to find this. I just kind of Googled what in my quick research of what a writ of error was and trying to find some history. But you can find this. It's not out of anybody's special text. But it goes on to say general usage, and you can take this part of me reading this at any point and use it for your teachings, if you like. But it says general usage of the writ, right? And then this section says Coram Nobis, before us the king, i.e., and this is parentheses, before us the king, i.e., the king's or queen's bench. The king or queen's bench, King or queen's bench. Somebody said bench means bank one day, but I'll let you guys figure that out. Where that came from is so called from that clause in the old forms which describe the record and process as remaining, before us, quae Coram Nobis resident, Coram Vobis, before you, the justices. Now this is the other one. So, was the corresponding term used in common pleas? So this is the other one. In the United States, Coram Nobis is the name generally employed, although some courts use Coram Vobis to refer to a writ directed by a court of review to the court which tried the cause. See, that's what the part I was talking about. Another, administrative body, court of review, would talk to another court or a lower court. And then it goes on to say, from earlier times, the writ has been used in both criminal and civil proceedings. Islam. And that's, I just wanted to put that out there because, again, it's broad, right? So criminal and civil procedures, proceedings. You can go in, find the errors, fix the errors, bring the errors to the court's attention, and possibly, overturn a judgment if need be. With the power of Allah and the will of the law, so to speak. But you've definitely got to do your research. Definitely got to check into it. But more about this writ of Coram Nobis, right? The distinction between an ordinary writ of error or appeal and a writ of error Coram Nobis is that the former is brought for an error of law apparent on the record and takes the case to a higher tribunal, while the latter is brought for an error of fact, right? So errors of law versus errors of fact, not appearing and lies in the court which tried the case. A writ of error Coram Nobis is not an appellate remedy. I repeat, a writ of error Coram Nobis is not an appellate remedy. The purpose of this writ is not to authorize a court to review its opinion, but only to vacate some adjudication made. Right? Not to, review it, not to review the opinion, but to vacate it. Again, you're trying to get rid of it. You're trying to overturn it. Islam, we'll get into vacate. Read vacate. Just for clarity. Because you have to be aware of what it is you really, want to do. What is your end goal here, Islam. So, coming out of Black's Law 4th edition, page 1717, vacate, to annul, to set aside, to cancel or rescind, to render an act void, as to vacate an entry of record or a judgment. As applied to a judgment or decree, it is not synonymous with suspend, quote unquote, which means to stay enforcement of judgment or decree. To put an end to, as to vacate a street, to move out, to make vacant or empty, to leave, especially to surrender possession by removal, to cease from occupancy. See also vacancy. All right? So, when you're dealing with a writ of error, especially according to this, let me just read this part again just to make sure I'm understanding this correct. As I'm reading this to you all, the distinction between an ordinary writ of error or appeal and a writ of error Coram Nobis is that the former, so the writ of error or appeal, is brought for an error of law apparent on the record and takes the case to a higher tribunal. Right? While the latter is brought for an error of fact, not appearing, so the facts are not in the, it didn't appear in the record for whatever reason, either the judge took it out, either the judge overruled you on that particular thing, or magistrate, they quote unquote overruled you, or they denied, they turned your writs or your pleadings, or even, because some people, that you're not really supposed to plead, but you're actually supposed to file the writ and file affidavits of fact, and the facts are supposed to speak for themselves. The law is supposed to, take its due course from that point. But, over time and things of that sort, people had to make money, so, you had to set it up in a way to where, people couldn't legally defend themselves, and, you were legally considered to be incompetent, and legally somebody had to come in and speak for you. And, you have to pay them for that service at that point, because, you can't do it yourself anymore. But at any rate, I digress. A writ of error, Coram Nobis, is not an appellate remedy. Right? The purpose of this writ is not to authorize the court to review its opinion, but only to vacate some adjudication made. And should the error alleged be in the judgment itself, then remedial action must be sought through appeal or writ of error. Right? So you either got to appeal the case, or you file a writ of error to show, where they messed up. The facts upon which the writ of error, Coram Nobis, is sought must have existed at the time of the pronouncement of the judgment. The writ, meaning they can't, come after. They can't come after. Not necessarily they can't be discovered after, but they have to exist. The writ will not lie to contradict or put in issue any fact that has already been adjudicated, even though erroneously decided. Right? The reason the fact was not disclosed at prior trial must have been due to fraud, duress, or excusable error, and not negligence on the part of the party now seeking the writ. So when they ask you got any more questions, that's your last time to make your your last stand, so to speak. Say whatever you got to say, because otherwise everything else is going to be lost in under some other things. If you follow me, it's going to be lost. You got to preserve certain things for the record. Islam. So don't ever be afraid to speak your mind. If you have something on your mind to say. Islam. Moreover, the fact, and just speak, and make sure you speak in an intelligible tone and all that good stuff. Moreover, the fact in question must be such as would have prevented rendition of the judgment at the former trial had it been available. All right. So on and so forth, such and such and such. So I let you guys read that. But vacating, writ of error, right, make those connections, and you're halfway there. You're halfway there, right? So another word that kept coming up, and I really wanted to get to you guys, because we've been talking about it and talking about it and talking about it, but I don't know if I've gotten it on the record for you guys, but I wanted to make sure I got it on here today. Consul, right? Page 388 in international law, an officer of a commercial character appointed by the different states to watch over the mercantile interests of the appointing state and of its subjects in foreign countries. There are usually a number of consuls in every maritime country, and they are usually subject to a chief consul who is called a consul general, right? In Old English, a consul was known as an ancient title of an earl. Catch that, all right? Now, under Roman law, and this is interesting, during the Republic, the name quote-unquote consul was given to the chief executive magistrate, two of whom were chosen annually. The office was continued under the empire, but its powers and prerogatives were greatly reduced, right? Because magistrates, don't necessarily have the same power as Article 3 judges, because they're lower. But chief magistrates were known as consuls, right? And that's just, American versus Roman law distinctions. The office was continued under the empire, but its powers again and prerogatives were greatly reduced. The name is supposed to have been derived from consulo, to consult, because these officers consulted with the Senate on administrative measures. So they had some type of legislative duties too. Now, make a distinction, whereas in America, Al-Marat was supposed to have, under the Constitution, 3 separate branches of government that are distinct. Executive, judicial, and legislative. Islam. But, goes on to say the word consul has two meanings. One, it denotes an officer of particular grade in the consular service. Two, it has a broader generic sense embracing all consular offices. Right? Now then right below it, it says, see also Foreign Services Act of 1942, 222 USCA, subsection 801 et sequa. Right? Then right below that, it says consular courts. Islam. Because, they shut down the consular courts back in the 50s, say by around 56, give or take. Consular courts, and it says, I quote, courts held by the consuls of one country within the territory of another, under authority given by treaty for the settlement of civil cases. In some instances, they have also a criminal jurisdiction, but in this respect are subject to review by the courts of the home government. See Revised Statute U.S. subsection 4083, title, or number 22, or title 22 rather, USC. It doesn't say title 22, but I know that's what they're referring to. But 22 USCA, so United States Code annotated subsection 141. And we already know what 222, chapter 1, chapter 2, section 141 is alluding to, Islam. So, getting that into the record, we understand who the consuls are, we understand consular courts, but, from a functional standpoint, realize, again, that operating as minister or consul, you're going to have to, notify these courts and these various bodies as to what's going on with the situation and where, certain people are messing up and not doing their job. Because otherwise, if you don't, certain errors at law, be it at fact or at law, may or may not hinder you or may cause further damages and further, harm and injury to the people. Islam. So, again, always do your due diligence and at that point, let the rest be in Allah's hands, so to speak, because it's the law should take its course from that point. Islam. So from that, I wanted, again, another definition. I just wanted to go over, get it on the record for you guys. Because it kept coming up again and again. Coram or Coram, Coram, depending on who you're asking. That on page 406 means, and it's a Latin word, before. So Coram means before, in presence of, right? Applied to persons only. So before. So, you know, in the presence of. Before, in the presence of. And it applies to persons only. Before, in the presence. All right. So now we're going to go into some of the other, you know, extensions of that. Or variations, compound words that's been made with that. So, right quick, the one I wanted to talk about, because it's in the text, it was in our homework, Coram Nobis. Before us, ourselves. Before us, ourselves. Before us, ourselves. Ourselves, Lord and Master. Before we the people. Islam. Alright, anyway. Before us, ourselves. The king, i.e., in the king's or queen's bench. Applied to writs of error directed to another branch of the same court. For example, from the full bench to the court at Nisi Prius. Nisi Prius. Nisi space Prius. And I'll let you guys look that up in your own time, right? But it says see writ of error, right? And so then the next one, you know, Coram non justi, in the presence of a person, not a judge. Coram probus, before the peers or freeholders. Islam. Coram sectatoribus, before the suitors. Coram vobis, and there you go, before you. A writ of error directed by a court of review to the court which tried the cause to correct an error in fact. Islam. But it says see writ of error, and I want to, you know, I didn't have that in my list, but I want to go on and get that on the record, because we can't talk about the writ of error and not define the writ of error. Of course, that would be, you know, asinine. So, you know, shoot me if you're upset. I didn't put it on the list, but I figured you would have been, you know, figured it out. You know, put two and two together. We're talking about the writ of error. Look it up. So anyway. Let me just check on the class. Make sure. All right. So Islam. So writ of error, and it's a pretty short definition. It's kind of long, but it's pretty short in comparison. Writ of error: a writ issued from a court of appellate jurisdiction directed to a judge or judges of a court of record, requiring them to remit to the appellate court the record of an action before them in which a final judgment has been entered, in order that examination may be made of certain errors alleged to have been committed, and that the judgment may be reversed, corrected, or affirmed, as the case may require. Islam further goes on to say, it is brought for supposed error in law apparent on record, and takes case to higher tribunal which affirms or reverses. It is commencement of new suit to set aside judgment, and is not continuation of suit to which it relates. And unless abolished by statute, is writ of right applicable to all cases in which jurisdiction is exercised according to course of common law, but is inapplicable to cases not known to or in derogation of common law unless otherwise provided by statute. Quote unquote, appeal is a process of civil law origin that entirely removes cause to appellate court, subjecting facts as well as law to review and retrial, while writ of error is a process of common law origin and removes nothing to appellate court for reexamination except the law. So a writ of error is not necessarily, in terms of, you know, generally, it's general writ of error versus a writ of appeal, a writ of appeal, writ of error for appeal. Try to make a distinction argumentatively. the writ of error is a process of common law origin and removes nothing to appellate court for re-examination except the law, right? And then before that it says appeal, quote unquote, is a process of civil law origin that entirely removes cause to appellate court, subjecting facts as well as law to review and retrial. So, you know, when you're talking about a writ of error versus a writ of appeal, you gotta keep in mind one of them is talking about a finished, you know, adjudicated matter versus dealing with the law of something that's, you know, either in error at the moment or already decided. But typically, you're not removing the case to appeal it. You're not trying to argue the facts of the case anymore. You're saying that the law was not followed. You know, you're saying that some procedure was not followed, some code that that particular court states that they're supposed to be, you know, going by, or that they deem to be as law, was not handled accordingly. Islam, or if they're typically if there's a violation of Article 6, right? If they're violating those, you know, certain duties and obligations under the treaty, Islam, that's when the writ of error could be your best friend, right? Because, and when you check out the one from RV Bay Publications, it has in there and talks about that DOA or that delegation of authority order, which we know, just for the sake of conversation, is associated directly, and that language and that, you know, that framework, that concept comes from the fact that all, you know, officers, all judges, and everybody else are bound by that article. And anything, you know, any code, statutes, and ordinances to the contrary, notwithstanding. Islam. So we have, you know, again, we have a lot of things to keep in mind. We have a lot of things to pay attention to. And I just want to, you know, hit the, just for the sake of argument and for the sake of the record, give the definition for judicial writs, right, in particular. Judicial writs in English practice, the capias and all other writs subsequent to the original writ not issuing out of chancery, but from the court to which the original was returnable, being grounded on what had passed in that court in consequence of the sheriff's return. They were called judicial writs, in contradistinction to the writs issued out of chancery, which were called original writs. And this is just, you know, for historical purposes and understanding. Such writs is issued under the private seal of the courts and not under the great seal of England, and are tested or witnessed not in the king's name, but in the name of the chief judge of the court out of which they issue. The word, quote unquote, judicial is used in contradistinction to, quote unquote, original. Original writs being such as issue out of chancery under the great seal and are witnessed in the king's name. All right, then you got junior writ and then original writ, right? Because they were talking about original writ. So original writ in the English practice, Islam, an original writ was the process formerly in use for the commencement of personal actions. In English practice, so this is, you know, from the British Moors, right? An original writ was the process formerly in use for the commencement of personal actions. Personal actions. It was a mandatory letter from the king issuing out of chancery, sealed with the great seal, and directed to the sheriff of the county wherein the injury was committed, or supposed to have been committed, requiring him to command the wrongdoer or accused party either to do justice to the plaintiff or else to appear in court and answer the accused against him. So you either got to do justice or answer, you know, the plaintiff. You know, answer the accusations against him. This writ is now disused, according to this definition, disused, the writ of summons being the process prescribed by the Uniformity of Process Act for commencing personal action, and under the Judiciary Act 1873, all suits even in the Court of Chancery, are to be commenced by such writs of summons. So according to that particular act, it goes by writs of summons, de jure or de facto, depending on how you want to argue that particular act. Not here to discuss that today, but I'll let others build on that in time as we go forward. But I just wanted to, again, get those certain definitions in, in the record so that you guys can, begin to get those wheels turning. And I got some other definitions, but I'll pause for the calls right now and ask, are there any questions in the chat? Any current questions, because it is 7:46. We're at the halfway mark, rather. We got about an hour left, a little bit under an hour left in class here, and try to go to the 8:30. All right, trying to go to 8:30 today, and then we'll try to lock it up till next time. So when keep from getting the rest of these definitions, I just want to again get some other things onto the record. So this is coming. If you've ever had the pleasure or chance to contact or be in contact with the wonderful people over at rvbaypublications.com, and you're ever so generous enough to donate your finance and or time to the cause, you may receive a pamphlet that looks like this. All right, and this is really just an informational piece, in my opinion, but it has a lot of vital keys, that anybody just coming in or anybody trying to figure out, all right, what are Moors about? You know what I mean? How are they, doing these things? How are they able to be so effective? And I would argue it's because we have those who have our eyes to see and ears to hear, have a firm understanding of the power of the protocols of liberty and or, in this case, notice, and how notice can be effective in terms of securing one's liberty with certain things. Because defense wins championships, as Lombardi said, right? For all those who like sports. Due to the fact, and I'm just reading, a couple of things here. Due to the fact that the Union States corporate state agencies and quasi-government agencies have instituted the colorable practices of birthright theft, it is in the natural people's best interest to notify or to give declaratory affidavits of facts to all parties of interest. These shall serve as notice to principals and to agents that there shall be no assumed jurisdiction in matters concerning Moorish American nationals. In ideal circumstances, when government is operating according to constitutional limitations, such protocols would be less necessary. And this is, wholly true. In a perfect society, in a perfect world, none of this would be necessary. Nunaji would not be online having to do these classes. There probably wouldn't even be, half the stuff you guys see in terms of the activity with Moors. Because, let some old jokers tell it, as I've been told, this stuff is so dangerous, this information is too much to be told to any one person. You know what I mean? These are supposed to be all the hidden secrets of the ancients, Islam, because as Moors who study, we understand we're sitting on the keys of civilization and society, Islam. And that's some powerful science to be sitting on. But, with great power comes great responsibility, Islam. So, I reiterate these points for that very reason and purpose. So I read it again. In ideal circumstances, when government is operating according to constitutional limitations, Article 6, such protocols would be less necessary. However, the fact remains that the opposite is true. corrupt government officials and personnel at all levels, federal, state, county, and local, are consistently violating the Constitution to which they are bound by law to support and uphold, thus necessitating the unorthodox issuing of writ on a massive scale. The point of the writs being sent to the various departments is to notify them of criminal activities among the local and state officials. They have a fiduciary obligation to act or to pass the complaints on to the properly authorized government agency to investigate the criminality. If not, they too are in conspiracy in such matters. For the record, you might want to check out Title 18, maybe 241, 242, just saying. RICO laws, I don't know. I'm not, I'm not an attorney, not a lawyer. This is not, legal advice in any way, shape, or form. This is, just my personal passing thoughts and opinions as an active Moor, of course. Islam, they have a fiduciary obligation to act or to pass the complaints on to the properly authorized government agency to investigate the criminality. I don't know. They also might have codes of ethics that may, require that too. Under state, laws and oaths. I don't know. You might want to check. I don't know. Not sure. Just being 100 with you. If not, they too are in conspiracy in such matters. The paper trail of evidence produced by active Moors and other constitutionally loyal citizenry affirms these facts, quote unquote, for the record. Check out, I believe it's MoorishPublicRecords.com, or if you just Google, public records of Moors public records, it should come up. Or just check out MoorishDirectory.com, links page. You'll find it right there, tucked away somewhere. Ever so nicely, ever so ever so neatly. Pardon me, because it's not nice at all. It's very neat though. Keep in mind that Article 3, Section 2 of the Constitution also deals with matters of quote unquote diversity of citizenship in controversies to which the United States is a party. Thus, the governmental positions of ministers and consuls come into play in international relationships, even in territories where different nations may be operating in the same territory. So if I'm an Al Moroccan in Al Morocco and they're in, say, the corporate auspices or claim to be in the corporate auspices of, say, I don't know, a district of Columbia, and, either party injures, one or the other, I believe, based on my studies, that the rules of diversity of citizenship would call for Article 3 court to hold jurisdiction over the matter, original jurisdiction, so to speak, not, subsequent or appellate jurisdiction, but original jurisdiction over the matter, if my memory serves me correct. And with that, naturally the matter should be removed to the, respective district court or, the Supreme Court. But oftentimes, as the facts and the record has proven time and time again, these corporate war state initiated vagabonds and highwaymen initiate certain kidnapping activities and railroading of sorts of people through these makeshift tribunals and what they like to call courts, and violate people's liberties, violate people's rights, and tell people that they owe a certain amount of specie to them for whatever made up reason that they had. And there were some points or some reports coming out and some different things that I was looking at, in the news and in media that were reiterating some points that, Moors have been talking about, time and time again, about how the prison industry and the, you know, slavery and the slave patrols and police and, you know, like I said, the prison industry, they all have this, how should I put it, convoluted marriage. They are kissing cousins of the same kind and bloodline, same lineage, so to speak. And in that, the very temperament and manner that you see the slave patrols, you know, operate back in the 1800s and early 1900s, you will see in the early 1900s and mid and early 2000s Islam, in the form of the, you know, Negro codes, the black codes, civil, quote unquote, civil law, statutes and ordinances and what have you, and, you know, just general abuses of trust and character, you know, galore, really, because at the end of the day, these criminals that, you know, came over through the popes of Rome, you know, from the doctrine of discovery, Dum Diverses, you know, and under the auspices of Secuva Trust at 1666, and generally just, you know, all manners of and directions and orders of the Roman Curia, you know, for the sake of conversation, have allowed themselves and built for themselves a mental space within the minds of the people that creates for them a blockage to appreciate, acknowledge, or recognize their own in so many words, to the point that when you start talking about the law, you start talking about the Constitution, and this is, you know, what I was realizing as I was coming into the movement, is that you got a lot of Moors who, you know, been dealing with dirty Moors and then, you know, just getting done dirty in so many different ways and you know, in so many different instances, they totally lose any respect for the law, right? Which in their minds, or I should say in their minds, they think is the law, but in actuality is just de facto government. You know, it's just colonialization, which you never were supposed to respect colonialization in the first place. Colonialization is the stated theft of, you know, natural people's lands and their, you know, rights, life and liberty. So with that, what you got upset with was not the law. You got upset with colonialism, you know, and its abuse of the law, or its abuse of what appears to be the law, or the, you know, what in fact is the color of law, Islam. So be mad at that, all right? Don't call it racism. Don't call it colorism. You know what I mean? Don't call it all these other isms, because what it really is denationalization and you know, acts of colonialism. Only, you know, colonialization is the closest thing to it, or genocide. You know, if you want to go all, you know, keep it all the way funky. But, you know, realize that these are the terms, these are the phrases, you know, the magic phrases that allow others to know that you are acting based on a right to self-determination, that you are acting based on a right, you know, to self-defense, you know, self-preservation. Islam. These are the words, these are the buzzwords to allow others to know, okay, he might have a clue about some international law. We might want to, you know, back off of him because he might be able to enforce some kind of protections for himself against us that might just bankrupt us. He might just come at us in our personal and corporate capacity, and he might just, you know, again, bankrupt the whole entity if he you know, I don't know, if he actually knows who he is and can demonstrate. Oh, he demonstrated he was an heir this time. Damn it, I can't kill him. You know what I mean? Because at the end of the day, his people are going to be able to take that Setsky trust that was set up, you know, and I'm not going to be able to take that vacation to the Poconos. I'm not going to be able to, you know, take Susie to the Bahamas next summer or this winter. You know, those are the things that are going to go through their minds, right? When you start demonstrating competence, Islam, and when you again are very aware and you're taking copious notes, that writ of error is going to help you again demonstrate that competence and show others, you know, publicly, based on the public cause of notice, that you know and that they know that whatever happened, and that, you know, it's not going to be tolerated, or it's not to be tolerated, or that you know that it wasn't supposed to be tolerated, or wasn't supposed to go on in the first place. You know, whatever the case may be. But typically you're dealing with issues, you know, of law or fact. And you have to, you know, make that distinction on your own. But, you know, when you're dealing with this writ of error, keep in mind, you know, what it's for, where it's coming from, and where you are in the process of things. Because, you know, again, it's not for appeal. You know, it's not an appeal. It's not a, you know, appealing anything. And, you know, just make those distinctions. So, just for the record, and I'm gonna finish some of this up, and I really wanted to read this because I love this little pamphlet here. It's jam packed with stuff, but conceptually I got to get this on the record for you guys because I think it'll really be some help. You know, hopefully it'll do some good. So, be cognizant at all times about the rule of law that is key to dealing with and maintaining good government. It is called, quote unquote, the separation of powers. Right? Separation of powers. The Constitution for the United States Republic of North America is based on that principle. A clear consciousness of this governmental principle must be present in the mental processes of all right law reasoning natural persons. It is also an important measure for distinguishing and identifying the barriers and limits of quote-unquote jurisdiction in any legal argument or controversy before any court or tribunal or subject matter in government. Right? And why are you reading this part? Why? Because if you study the case law, time and time again, you'll see the legislature or you'll see the courts make mention to the separation of the powers, right? If you check out, you know, a landmark case, Marbury v. Madison, they talk about that separation of powers. You know, they talk about this, and they talk about how the court under Article 3 it falls under the judicial branch, right? And they make, you know, determinations, and I'm paraphrasing, of course, you know, in a very inartful manner. They make certain determinations of law and fact, right? And they're the final arbiter on those laws and facts, right? Based on the law and the interpretation of the law, you know, based on the delegated authority given to them under Article 6 or, you know, in Article 3, or given to them under Article 3, limited by Article 6, you know, either way you want to look at that, and regulated by the various amendments. So when you're dealing with this writ of error and a magistrate or a judge is, again, they're out of bounds, they're doing something they're not supposed to be doing, based either on the law itself, you know, from a jurisprudence standpoint, based on, you know, right law, or even based on their own procedure sometimes, and oftentimes it's based on their own procedure. The writ of error is a ways and means to catch them in that lie, you know, in that act, that bad act, you know, and to help correct that. Islam, pardon yourself. So I wanted to go over the writ of error. I wanted to talk about this because I felt like it really, you know, if you understand certain basics, you know, you like Ty says, you'll be able to put your skates on, You know what I mean? And once you got your skates on, you move in there, baby. That's, man. And these wheels are Teflon, you feel me? These are Teflon wheels. So just to reiterate and just to, you know, further drive the point home, checks and balances, right? And I'm gonna finish this, and then we'll just open the floor up because we got about 30 minutes left, and I'll just, you know, finish the floor up with talking points and, you know, other little fun things of history and all of that. And we'll just talk about some current events. The word check means, quote unquote, an abrupt halt or stop, to rebuff, a restraint or control, etc. The word, quote unquote, balance means a stable state or condition characterized by cancellation of all forces by equal opposing forces. Balance brings about a stable, harmonious, and satisfying arrangement or proportion of parts or branches of government by design and composition. The Constitution is structured to ensure that no branch of the federal government becomes too powerful and thereby upsets the balance, stability, and harmony of powers delegated to them. Such an imbalance promotes tyranny. There are three branches of government: the legislature, which I already read this, I already told y'all guys this, the legislative, the executive, and judicial. This is how checks and balances works. The legislative branch of government, the Congress, makes law. The president has the power to, quote-unquote, veto or turn down a law proposed by Congress. The, quote-unquote, veto powers of the president can, quote-unquote, check the lawmaking power of the Congress, period. That doesn't mean that the president can deny any law passed by Congress. Wouldn't that give the president, quote-unquote, executive branch too much power? Question mark. Then comes the quote-unquote balance, right? The balance part. The Constitution provides that the Congress can override the veto of the president with 2/3 votes, both houses, with both houses of Congress. This way, the Congress can check the lawmaking power of the executive branch of the president. The Supreme Court can also become involved in lawmaking by virtue of having the power to interpret the meaning of laws and making such declarations known in its decisions and rulings. So if a court makes a decision or a ruling on a matter, right, that can be used as a check or balance. That's very important to keep in mind when we're talking about the writ of error, because the writ of error within that structure can help to support those checks and balances or effectuate those checks and balances. Islam. So keep going. Furthermore, the Supreme Court can declare that certain laws are in conflict with the Constitution and are therefore null and void and cannot be enforced. A violation, so it goes on to say, a violation of the checks and balance principle established by the ancient principles adopted for the Constitution for the United States Republic brings about strong possibilities, for corruption, despotism, tyranny, and anarchy. Unfortunately, and due to European colonial influences, the Inquisition-oriented persons having years, this is what I was talking about earlier, years of monopolizing powers in government, the checks and balances rooted in Constitution law have been subverted, and I would dare say perverted. It doesn't say that here, but I would dare say they've not only been subverted, but they've been wholly and intentionally perverted. And I say that with particular emphasis for a reason. Islam, we, the Aboriginal natural peoples, Moors, have been colorably and adulterated, by the way, have been colorably held to forced servitude under European occupation of our lands, have suffered the far-reaching sting of anarchy in government. The Constitution for the United States Republic is based in and is heavily influenced by allodial principles. Moors, we're supposed to be guided by allodial principles. Islam, I don't know what all this other stuff is. And I'm not even going to get into it. But I don't know what all this other stuff y'all talking about is if it's not dealing with the allodial principle, if it's not even sounding like that. If it's not coming from that framework or frame of mind, what principles are you talking about? Islam. Because that's what the Constitution is based off of. That's what Moors, that's where active Moors are coming from. We're dealing with allodial principles. Islam, where they come from, they came down and are influenced by Moorish jurisprudence. Research the Renaissance, 14th, 15th, and 16th centuries in Europe, because that's when we gave it to Europeans. That's when we translated, from Arabic to the various languages, German, English, French, out of our Moorish Latin, which is now known to Spanish, into the other languages, so on and so forth, etc. And it goes on to say, keep in mind that the governmental standards of Europe, as distinguished from Moors/Muslims, is that of feudalism. Feudalism is the opposite of allodial. This is why there have been serious clashes in the forms of government and in the nature of attitudes towards the fundamental, divine, and unalienable rights of natural people. Compare feudal to allodial. Islam. So for some of these Moors and quote unquote grand sheiks who are just telling you, oh, just fill out the form and and as you're growing and as you're coming out of whatever situation you're coming out of, you want to be stable. You want to be reasonable about how you're moving. So just be aware as you're studying and as you're gaining information to be cautious about when you apply it, because certain, like I said, certain areas are a little more, dangerous than others, depending on whatever circumstance, situation you're talking about. So, do your due diligence at all times. Islam, always do your due diligence. So, I just preference that to say, because oftentimes, and in starting this, I guess this leg of the series of teaching, I got a lot of different questions from people. And I just wanted to make sure that, people weren't taking these lessons lightly, because these are keys, to your posterity. These are ways and means in so many ways to defend yourself. And it's often been, in my past experiences, with teams and things of that sort, and understanding of sports, that the best offense typically is a good defense. Islam. And if you're into football at all, I believe it might have been Vince Lombardi or someone of his stature and character that said something along the lines of defense winning championships. In our recent era. But just keep these tidbits in mind. They're just little well-seasoned breadcrumbs for those who have eyes to see and ears to hear. But we are going to get right into it. So the definitions for today, and I'm gonna start from the top of my list. I got a little list today to keep me on track. It's long, so that we can move right through it and get everything we need to on the record, because I often want to get so much on the record. But anyway, free white persons. So first one, Islam. Islam. Free white persons. All right. Yep. So I think we got the Ustream going. Get this tweet out right quick. And welcome to the Friday class. I am Nuna GL. And welcome. Thank you for joining us yet again. Islam, everybody checking us out on the Ustream and the YouTube world. Thank you. Without you, this wouldn't be possible. So we thank you guys, of course. Today, Islam, we are supposed to be talking about the writ of error. Islam. And I gave some homework through the active space. If you I linked up with activemoors.com, and we had a few definitions and words that we were supposed to go over. But today's class is supposed to be writ of error, Coram Nobis versus Coram Vobis, in a review of the vital protocols of liberty. So we're going to get right into it, and just for the sake of time, I'm going to run through some of the definitions. Some of them we already have covered before. Some of them were part of the homework, but I just felt like they would be pertinent to go into. But before we do that, I wanted to read just two, actually, 2 or 3 of the oral statements and prophecies, Islam, and then we'll just jump right to it. So, number 35, we the Moors have the blood of every nation flowing through our veins, thereby bringing about a cross spirit. 36, the Italians have our blood, the blood of the Moors, mixed in their veins. That is why they are so mean, quote unquote. Number 37, quote, we, the Moors, are a hard-headed, stiff-necked, mean set of people that have never did anything except at the point of a sword. Islam. And then this next one, which, you know, for better or for worse, take it how you want to. 41, quote, I had to go around my elbow to get to my thumb to get what I wanted established in this government. I repeat, quote, I had to go around my elbow to get to my thumb to get what I wanted established in this government. Islam, that's number 41. So, with that being said, sometimes it's not the help that you're looking for is not always going to come in the form that you expected. The way that you go about something isn't always going to be the way you may right now at this very moment think that that's the way to go about it, right? And sometimes you in the terms of you know, doing things the right way, you might go out of your comfort zone a little bit. You might do some things in terms of work, or you might have some areas in terms of study that may be a little more intense or a little more draining than usual. So as a precursor, as a warning, you know, I just want to let everybody know that when you're studying, you know, don't so much make it a habit of going hard 24/7 and staying up every night, all night, and, you know, not being able to do what you need to do. Because at the end of the day, you do have a life to live, you know what I mean, of those areas, and who more or less migrated to Northwest Amexem in this case. All right. And just for the sake, well, I'll wait on that because we've done that before. So I'm gonna stick to this list. Color is next. So yeah, I just wanted to put free white persons on the record because, again, I was getting a lot of questions, and if you've seen it in the past videos, you know this been coming up lately. There's been this question between, you know, and we actually had a class, you know, coming through the Moorish directory. Shout out to Sharice L. And Brother Rami Il and Brother Cujo Awa Il for their naturalization versus nationality class, right? And in that they make some clear distinctions between, you know, those definitions, which I won't necessarily get into in great detail to here, but suffice to say that if you are able to make those distinctions, right, between what applies to nationals versus what applies to naturalized citizens, right? So nationals of the land naturalized citizens, right, who are naturalized by the government or, you know, and or the people of the land in some way, shape, or form, you're gonna constantly run into issues. And if you follow, right, conceptually, if you follow the citizens process, when you should be following, or protocol, when you should be following the nationals process or protocol, you're oftentimes gonna, you know, reach a dead end. And no, you know, I've built with numerous Moors. We've you know, dealt with different things, and the number of, you know, the one reoccurring thing, the common denominator, sorry, that I keep running into is that as we're growing, and this is why I preference, you know, applying certain information without having a true, full understanding of it and the application of it. You know what I mean? And, you know, truly being willing to demonstrate that for yourself. You know, once you, free white persons referred to in Naturalization Act as amended by Act July 14th, 1870, has meaning naturally given to it when first used, you know, one statute, meaning all persons belong to the European races, then counted as white, and their descendants, including such descendants in other countries to which they have immigrated, right? And it goes on to say below it, it includes all European Jews, more or less intermixed with peoples of Celtic, Scandinavian, Teutonic, Iberian, Latin, Greek, and Slavic descent. It includes Magyars, Lapps, and Finns, and the Basque and Albanians. It includes the mixed Latin, Celtic, Iberian, and Moorish inhabitants of Spain and Portugal, right? So right there, it tells you that free white persons are Moors. You know what I mean? They were the inhabitants of all these areas. They were known by all these various names, and the like, right? It goes on to say the mixed Greek, Latin, Phoenician, and North African inhabitants of Sicily, and the mixed Slav and Tatar inhabitants of South Russia, right? Period. And this is coming out of, again, Black's Law, 4th edition. For those who don't know, page 792. Now, right after that, it's going to make a clear distinction as to what free white persons does not mean. All right? Follow me. It does not mean Caucasian race, Aryan race, or Indo-European races, nor the mixed Indo-European, Dravidian, Semitic, and Mongolian peoples who inhabit Persia. A Syrian of Asiatic birth and descent will not be entitled to become a naturalized citizen of the United States as being a free white person. And that's, you know, more of a legal versus a lawful distinction. And then they make another legal versus lawful distinction. Nor a native-born Filipino, nor a native of India who belong to Hindu race, right? Which we know our Hindustani brothers are, you know, our brothers and sisters. But this is more so applying to the peoples